Welcome, everybody. Thank you so much for making time to be here with us at the very first session of our 2021 Summer Law Institute webinar series. It's been so nice to see a couple of familiar names showing up in the chat, folks who I know would have been with us in person if that had been a safe and good option for us. And we just are so grateful that you guys are still interested in law and in bringing new perspectives to your students and are able to join us in this very hectic and very, very stressful time. So welcome. My name is Michelle Thompson. I'm the Director of Capacity Building and Engagement with the Ontario Justice Education Network. And we are, as I said, kicking off the SLI today. If you haven't seen already, my co-host and colleague, Christy Pagnuti, is here as well and is going to be helping me behind the scenes troubleshooting any technical issues, and you can reach out to either of us in the chat if you have any challenges or if there's anything you want to ask. Just a few housekeeping items before we begin. You do not have access to your cameras or mics, so you're safe if there are people wandering around in their underwear behind you. No worries about that. It's happened to all of us. If there are any particular links or documents that our presenters refer to, we'll do our best to find a hyperlink and drop it in chat so that you can keep track of that. This presentation is being recorded, and so we're going to make sure that the video of this is available on OJEN's YouTube channel. Usually it takes us a couple of weeks to get it up, but it'll be there eventually. If you have any questions or comments, go ahead and use the chats. And we'll save a little bit of time at the end of the session to talk through all of your questions and have a little bit of discussion about the issues we're talking about today, which is young workers in 2021 and some of the large structural obstacles that are facing them. But before we get into the legal content, we want to start by acknowledging that we are gathered upon the traditional territories of the Mississauga of the New Credit First Nation, the Anishinaabe, the Haudenosaunee, the Wendat, and Huron nations. And while we're talking today about Canada and Ontario's approach to employment law, we also want to pause to acknowledge the distinct legal traditions of those nations, all of whom had their own ways of understanding labor and the distribution of work and the benefits of that work. And it's a good reminder to us that our current way of organizing labor is not the only way, and it's not even the only way that has existed on this land in the space that we are. And in making this acknowledgement, we also want to keep in mind that Toronto remains home to a large and diverse Indigenous population. And we know that many of you are calling in from outside Toronto as well. And so we encourage you to take a moment to learn more about and think more about the nations that have been the historical stewards of the places that you are calling in from. With that said, I will start by introducing our first speaker, who's going to be Joshua Mandryk from Goldblatt Partners LLP. Josh has been a fighter for workers' rights for a long, long time. From union organizing law to employment class actions to collective bargaining and grievance arbitration, Josh is proud to help advance the rights of working people day in and day out. In his general labor law practice, Josh acts for unions in grievance arbitration, collective bargaining, and public policy or law reform consultations. In the class action side of his practice, Josh helps groups of non-unionized workers join together to enforce their rights at work with respect to issues like employee misclassification, wage theft, and unpaid overtime. Just a couple of things that might be relevant for the conversations we're going to have today. Josh is also the former executive director of the Canadian Intern Association, which published the Canadian Intern Rights Guide, a union-made Know Your Rights guide that was distributed on college and university campuses across the country. And that's only part of why we were so happy to have him here talking about student workers in the context of internships, both academic and outside of the school system. So with that said, Josh, I'll turn it over to you.
Thank you so much, Michelle, for the very kind introduction. I'm really excited to be here with you all today and to talk about these issues. It's been a few years since I've done one of these talks around unpaid internships, but it is a topic which is very close to my heart and something that I was very involved in as a student and then as an articling student. And I've now graduated a little bit out of that realm. I'm no longer a student myself, but in my legal work, I'm able to to do some related work, and we'll talk a little bit about those issues. I'm going to share my screen now, and I have a bit of a presentation that we can go through. So let me just get that going. Okay, so I'm here to talk to you today about unpaid internships, work credit programs, and youth labor. And there are countless topics we could discuss within youth labor. And so I'm going to really focus on unpaid work and the issues surrounding various types of unpaid work. And this includes volunteerism in addition to work credit programs and unpaid internships. So for today's talk, just to start it off, just some terminology. Oftentimes the term unpaid internship is used to refer to unpaid internships, whether they are for school credit or whether they're not attached to a school program. Today, when I use the term unpaid internship, I'll be talking about the unpaid internships which aren't attached to high school, college, or university study. When I talk about work credit programs today, I'll be talking about those co-op or placements or internships which are attached to high school or college or university. When those can be paid or those can be unpaid, depending on the program and the rules. I'm also going to talk about volunteers. And volunteers, I think we all sort of intuitively know what a volunteer is, and we know that it's a bit different from an unpaid intern, but it's an issue that I think is related to these issues. Finally, I'm going to talk about some of the rules in Ontario and federally, both in Ontario under the Employment Standards Act and federally under the Canada Labour Code. The vast majority of workers in Canada are provincially regulated, which means here in Ontario, they're subject to the ESA rather than the Canada Labour Code. And I'd venture to say that the overwhelming majority of the workers that are, students and placements that you might deal with are probably subject to provincial jurisdiction. The federal jurisdiction would deal with things like telecommunications, the banking sector, the federal public service, and a few other narrowly defined industries. But the bulk of the economy is provincially regulated. So with that, on to sort of a high-level overview of today's chat. So first, I want to talk about the emergence of unpaid internships and work credit programs, as well as the youth-led pushback that followed. Then I want to talk about changes regarding the regulation of unpaid internships and work credit programs, which came about in response to that youth activism. Then I want to talk about where we are now after these changes with respect to internships, work credit programs, and also the volunteer issue. And then I want to talk connected with that about some gaps in the law and some challenges that remain. And finally, so that we can round it off in a constructive fashion, I want to talk a bit about how educators can help and how you can be involved in these issues. So without further ado, some backdrop on the rise of unpaid internships and work credit programs. So historically, internships have been limited in the past to professions like medicine, but over time expanded to other industries and sectors. In Ontario, there was a 6-part so-called trainee exemption, which was introduced into the Employment Standards Act in the early 2000s. And this essentially provided that a so-called intern or trainee had to be paid unless they met all 6 requirements. It was very difficult to meet all 6 of these requirements. However, the lack of clarity in the law led to a lot of employers relying on this exemption and hiring unpaid interns. We saw a steady growth in unpaid internships in the years that followed the introduction of this exemption. But then we really saw an explosive growth in the practice following the Great Recession. And then at the same time, we saw growth in work credit programs through high schools, colleges, and universities as work integrated learning became a more important pillar. And we also saw mandatory volunteerism introduced. And all of this led to a growth in formalized unpaid labor. And I would suggest that nowadays for many young folks and students that an unpaid internship or a work credit program has really become the new normal for entry into the job market. It's almost expected that folks are going to do these nowadays. And I have some concerns about that. And it's not just with unpaid internships not connected to school, but also with work credit programs. And I do want to preface this by saying that I know that most of you folks are educators and most of you work very hard to look out for the students that you supervise for credit programs, and ensure that they have meaningful opportunity. And so, I don't take this in any way as a criticism of the important work that you folks do. These are really sort of broader policy concerns that we have with these issues. These are some of the problems that I see. The first is that unpaid internships, broadly speaking, displace paid work opportunities. And that's a given when you think about the volume of these placements. There are tens, if not hundreds of thousands of these placements happening every year. We're talking about millions of person hours of work. And a lot of this is important work that helps employers and helps organizations and would otherwise be done by somebody. The second is that these placements can reproduce inequality and privilege. And the archetype of this, if you think about it, is the UN internship that many folks would be aware of. So, you get an internship with the United Nations. It's very prestigious. It helps you with your future. It looks good on your resume, but it's unpaid, and it's in Geneva or New York, which are incredibly expensive. And if you're not someone of means, it's very difficult to actually be able to afford this and do this. And so we see how the cycle of privilege reproduces itself when opportunities like this are restricted in this fashion. Unpaid internships also have gendered impacts, and they disproportionately impact newcomers to Canada. The gendered impact is multifaceted. I mean, first of all, we see unpaid internships being more prevalent in traditionally female-dominated industries, but we also see it in a more explicit and gendered targeting of women returning to the workforce after pregnancy and parental leave for unpaid internships. And you'll see this often in postings. It's often an explicit targeting, and obviously an impact that is disproportionate. As well, unpaid internships often target newcomers to Canada who need so-called Canadian experience requirements, and you often see this reflected in the job postings. And so it's it's an additional hurdle that folks have to end up doing and going through to get work opportunity in Canada. And it leads to intergenerational inequity, because this is something that has come about now and wasn't necessarily the case for generations past. And so it's really can be understood as an intergenerational transfer of wealth, a regressive transfer of wealth. And just broadly speaking, until recent years, I would say that the regulation of unpaid internships could be characterized by lack of clarity, by gaps, and or by legislative silence. I'd say the trainee exemption in Ontario provided a real lack of clarity. There were gaps around health and safety protections, and there was legislative silence under the Canada Labour Code. It just didn't address issues around unpaid internships, and there were some negative interpretations by government authorities that interpreted this as meaning that interns aren't employees and aren't protected. And then with respect to work credit programs, I'd suggest that there continues to be, the regulation continues to be characterized by overbroad exemptions, which leave too much of a loophole and leave it too much to employers and to educational institutions, rather than setting a stronger floor. But that hasn't been without resistance and fight back. And so we've seen around the world, there have been youth-led movements pushing back around exploitative unpaid internships, demanding fair pay and equal treatment. And these organizations haven't just focused their efforts on bad employers that have unpaid internships. They've been pushing governments for greater legal protections, for changing the laws to give them more and stronger and better rights. And this has been the case here in Canada as well. Michelle mentioned the Canadian Intern Rights Guide. That's a picture of some of these guides on the right. But here in Ontario and across Canada, we've seen this work from organizations, including the Canadian Intern Association, as well as Students Against Unpaid Internship Scams and other youth and student-led groups, which pushed for greater workplace rights for interns and for all young workers. Here are some photos from this other group, Students Against Unpaid Internship Scams. The right is a photo from one of their pressure campaigns, and the left is a photograph from a protest that they did outside of a pre-budget consultation. So there's a range of tactics, some of which are engaging governments for law reform efforts, and some of which are more direct actions, and we've seen this sort of around the world. And we've also seen legal strategies. There have been lawsuits and litigation regarding these issues. So on the right, screenshot from an article about some legal complaints which were filed by former Bell interns about their unpaid internship program. Ultimately, that program was canceled, and I understand that they don't hire unpaid interns anymore. Everyone there is paid now. On the left is a screenshot of a story about the S-trip class action. I'm proud to have been involved in this. This is the first volunteer misclassification in Canada, which was either filed and certified. The class action has been certified now, and it's the first of this kind in Canada. There's some of these in the United States regarding various programs as well, but this was the first here. And so the fight back has been multifaceted in terms of legal strategies, in terms of law reform strategies, in terms of protest, and it's gotten some results. We've seen some real changes over the last 5 to 7 years or so regarding these issues. First of all, with respect to health and safety, we've seen amendments in Ontario to the ESA to explicitly cover interns and co-op students and other types of unpaid workers. We've seen similar changes under the Canada Labour Code to bring them under coverage of the occupational health and safety provisions. We've seen the removal of this 6-part trainee exemption, and it changed the definition of employee under the ESA. And this essentially banned unpaid internships outside of the work credit context. So we've seen some real gains and positive improvements in these areas. But at the same time, we've seen a bit of an entrenchment and I would say a legitimizing of work credit programs that are not paid. So while we've been pushing against these exploitative unpaid internships that aren't attached to school, we've seen sort of a legal solidification of these unpaid programs. And so in Ontario, they actually expanded the exemption to cover private career colleges. So previously, high school programs, public college programs, public university programs were covered, but they actually expanded the exemption to cover private career colleges. And that was not something that was recommended as part of the Changing Workplaces review, but it was something that ultimately came out of Bill 148. And we've also seen no change to the exemptions for students in training for certain types of professions, which we'll talk about later. Sort of close to all of us, this includes teaching, it includes law. And at the federal level, we've seen changes enacted to clarify that unpaid interns, that you have to pay interns rather, unless they are doing it as part of a work credit program. And in the federal jurisdiction, it's been defined very broadly to include secondary or post-secondary institutions, vocational schools, or equivalents outside of Canada. So again, in the federal jurisdiction, you're seeing payment required for placements that are not connected to work credit programs, but then exemption from pay for work credit programs. And so I would suggest that this creates some serious holes. And when my image here about where we are now is a piece of Swiss cheese, and that's because I think that there are some real holes in this approach. So in Ontario, under the ESA, interns outside of school approved placements, they have to be paid in accordance with the ESA. High school work credit placements, they're exempt from the ESA. College, university, and private career colleges are similarly exempt from the ESA. Volunteers, there's a lack of clarity regarding the status of volunteers under the ESA. It's an area that has continued confusion, and I would suggest is being taken advantage of by certain employers, but we'll cover that in a little bit. And students in training for various professions like teaching and law and others, they continue to be exempt from important protections like hours of work, minimum wage, and overtime. And then federally, it's a similar story. So interns who are fulfilling requirement of an educational program fairly broadly defined, a work credit program, they do not need to be paid, but all other interns must be paid. In the federal jurisdiction, it's a little bit better than Ontario for work credit programs in that students in these programs are entitled to other basic protections. So maximum hours of work and break periods and rest periods and certain job protected leaves. So, there's some protection against the 70-hour work week for these folks. They're not going to be working all day, every day with no breaks, but they're still unpaid. And, pay protection is really sort of the most important core employment standards, and they're exempt from those. And of course, they do, of course, under the federal jurisdiction, have health and safety protections, the same as in Ontario now, which is good and important. I now just want to talk a bit about some of the challenges that remain with respect to the different types of placements. So we know the exemptions that exist for high school placements, and I would suggest that this is problematic for a number of reasons. These exemptions raise concerns regarding the displacement of paid work and the exploitation of young workers. We also know that not all placements are created equally. So some students might get fantastic opportunities and others not so much in terms of the learning they receive and in terms of the types of work that they're performing. And I know that it's a lot of work for folks to find these for people, and it's a challenge. I've had the benefit and fortune of getting to go to some of these classes, the pre-placement classes where I talk to folks about their rights, and I go around the room and ask them about their placements, and you see a pretty big disparity in my experience, at least. And I appreciate that it's tricky balancing the desires of students to gain work opportunities with the concerns around avoiding exploitation and displacement and other policy concerns. And my concern is that not dealing with these issues under the ESA downloads that responsibility to educators, to school boards, and to the Ministry of Education when it's basically an employment standards issue. There's also the high school volunteer issue, and this probably isn't as high on other folks' radar, but it's something that has always stuck with me, since my own experiences as a student having to do this. So as you all know, all Ontario high school students are required to complete 40 hours of community involvement in order to graduate. I am aware that this has been changed temporarily during the pandemic. We're just going to ignore the temporary changes and talk about the general the rule. So. And so there are some rules in here which stipulate that that work which would normally be performed by wages by a person in the workplace is ineligible for this time, and that's to try and avoid the displacement of paid work. But there's not a lot of guidance on this. And I would suggest that if you read through the rules from the ministry, that they otherwise broadly permit work to take place in a variety of settings, including business settings. If you look, you'll see that there's restrictions on, for instance, working in a factory, but that's only based on the minimum age requirements. So it contemplates that, a student under the minimum legal, or above the maximum legal age rather, or minimum, would be allowed to do their volunteer hours in a factory even, which obviously doesn't seem right. And it raises concerns regarding the displacement of paid work again, about lack of oversight, about the extent to which you can find appropriate and meaningful opportunities. Every single high school student finding 40 hours of this, it's very hard. I remember, and I know, and I see it from others. And also there's a broader sort of policy concern about, the implementation of this. And, is this about conditioning young workers to work for free? It's very difficult to challenge the notion of volunteerism in the abstract. I mean, we all probably volunteer a lot, and it's important, and we help our communities. But when you look at these programs in practice and how they work, there's some real challenges with them in terms of what students end up doing and the impact that it has when you consider that applied more broadly across thousands and thousands of students with 40 hours each. Post-secondary placements, we see many of the same concerns. So in Ontario, under the ESA, there's a full-scale exemption for these placements. Federally, there's a full-scale exemption from pay. There's other minimum protections, but they're not entitled to pay. And there's a lot of concerns with this. Again, displacement of paid work and the exploitation of young workers. I don't need to repeat that. In the post-secondary institution context, there's the unique concern, which I hear a lot of folks talk about the fact that they're essentially paying their college or university in order to work for a private employer for free. And that really bothers a lot of folks, and it's problematic, and it incentivizes employers to grow, or incentivizes institutions to grow and expand these programs because they don't need classroom space for them, and et cetera, et cetera. And these exemptions essentially mean that responsibility is downloaded to educational institutions to govern these. And this results in huge discrepancies across industries, across sectors, and between and across colleges and universities. So this speaks to the gendered impact and about how there's certain sectors and industries which you tend to see more paid placements like engineering, et cetera, which tend to be traditionally male-dominated industries. And then in the caring sectors, for instance, you may see far more unpaid placements. There's also discrepancy across institutions, and it's particularly more so in colleges. You tend to see institutions that actually mandate that the position is unpaid, so the student can't be paid even if the employer wants it to. Then you see some universities which are able to take more of a high road approach based on their student body and their skills and their programs, and try and insist and push for pay. So there's a huge discrepancy in these things, and it's concerning. And all of this raises the equity concerns that I talked about at the outset when we see about how equity cross-section applies to these different sectors and industries and institutions. And there's also professional student exemptions, and I'm sure that this is close to a lot of you folks as teachers and other industries that this impacts as well. But I do want to talk about a law example. And so, as you know, students in training for various enumerated professions, which include law, teaching, and others, are exempt from key employment standards protections like minimum wage and overtime and hours of work. And this essentially downloads the responsibility to professional regulators and leaves a lot of workers without protections. And so in law, there's been a push for the Law Society to do something about unpaid articling or underpaid articling. They've indicated that they were going to create minimum standards. They were supposed to have been in effect in May 2021. They are not in effect. It's unclear what the status of that is now. But, you know, law students and lawyers, you know, you might not think of as the most sympathetic folks. And certainly many law students get a great pay, and they have a good salary. And if you're at a place like our shop or Ryan's, you know, you're unionized as well. But there's great disparity, and there's a lot of folks who are articling students that work, you know, for minimum wage or less, or even for free. And here's a screenshot I've got here of an article that caused a lot of uproar around a placement that basically offered a transit pass as payment. Also, there's the issue around volunteer misclassification. Some anecdotal evidence suggests that the crackdown on unpaid internships, in addition to pushing placements into the work credit program stream, have also led to unscrupulous employers now just calling their unpaid interns volunteers instead. And you know, you can't just do that. The law recognizes that just because someone's a volunteer doesn't mean they are, and they can still be an employee. And the law recognizes a distinction between a so-called true volunteer and a misclassified employee. But there's a real lack of clarity, both in terms of regulation, legislation, or case law even on that distinction. The cases are very old. They sort of predate the unpaid intern issue. And if a court dealt with it now, you'd almost be certain that they wouldn't deal with it based on those old tests. And so, you know, this is sort of really begging for government to step in and actually provide some clarity. And finally, the last challenge is enforcement. And so, you know, we know that all non-unionized employees face real and significant barriers enforcing their rights at work. And this is even more pronounced for young workers and those trying to break into the workforce. You know, students are trying to get a leg in, and they're trying to get an opportunity, and they're trying to make connections. And even more so than other employees and other workers, if you file an employment standards complaint or make a fuss at work, you know, you risk being blacklisted and being outcast and missing out on future opportunities. And the ESA has never been proactively enforced particularly well by the government, but it's gotten worse in recent years. So proactive inspections are significantly down, which is unfortunate. And so there's a real problem with enforcement where, while in theory, not in theory, in law, unpaid internships outside of work credit programs are illegal, and you can't do that. But in practice, we know that employers continue to do this. And so here I've got a posting from one, and the font is too small. It'll get circulated, but I do want to highlight some things from this because it really highlights the problematic nature of these. And so this post asks, Above all, are you willing to sacrifice the short term for the long term? And it suggests that this is a 4 to 6 month unpaid internship and has the potential for renewal and or full-time status at the end of the internship period. So it's dangling the prospect of actual employment in front of the young worker. It says you must be willing to work from 9 a.m. to 5 a.m., 4 to 5 days a week. And it also specifically notes that it is, quote, open to new immigrants who match the requirements and are looking for Canadian experience, comma, women who are looking to join the workforce after a career break. And I actually came across we came across this after, I had set out the slide around the issues around the gendered impact and the impact on newcomers, but this really just sort of speaks to it so directly and really puts it front and center. And so finally, with all of these challenges laid out, just to talk about what you can do to help young workers, you can educate students about their rights and encourage them to critically assess these issues. You can do that in your classes, in particular, the pre-placement classes that you have. I know that I've spoken to some of these classes. It's one of the most enjoyable things I've done in terms of public legal education. You can carefully vet potential work credit placements to ensure they offer meaningful learning opportunities and aren't just cheap labor and unpaid work. I know that you folks do this already, but it's obviously super important given the lack of oversight. You can help ensure students perform volunteer work that serves a humanitarian, civic, or charitable end, isn't in a for-profit context, and doesn't displace paid work, helping to guide those positions. You can work with your school boards and your unions to try and push for stronger regulations and oversight regarding these issues. And finally, you can support student and youth-led advocacy on these issues, because the changes that we've gotten to date have been from young people fighting and pushing back. And to get further change and further improvements, it's going to be more of that. And in your role, you can support those students who are doing that, who are going to be the next generation of fighters on these issues. And that is all from me. I want to thank you all so much. Apologize to Ryan and Michelle in advance for taking a couple extra minutes. And I will now turn it over to you folks. Thank you so much.
Absolutely. That was so great and so reflective of so many of the conversations that we at OJEN have had internally, because as both a nonprofit organization with limited funding and also one that is really invested in the education system and in young people as being the ultimate beneficiaries of everything that we do, I feel like over the process of all these changes, it's been 10 straight years of constant conversation about how to really do right by young people who are trying to build themselves up and get experience, and also suffering the disparate economic impacts of the opportunities that are available to them. So I appreciate that systemic look at where we are. Let me quickly introduce Ryan White. So Ryan is a partner at Cavalluzzo LLP, where he's the co-leader of the firm's construction labor law practice group. He's a graduate of Osgoode Hall Law School, much like myself, where he received several academic awards, unlike myself, including the Nick McCombie Prize for the best paper on workers' rights. He's also spent time in the workers' rights division at Parkdale Community Legal Services, which many of you will know in Toronto. And he's been a longtime volunteer with the Workers' Action Center. During his education, Ryan was active with student government, including the University of Guelph Student Union, the Central Student Association, Osgoode Hall Student Caucus, and the York University Senate. And he's recently been counsel to many workers within the gig economy who are seeking recognition as employees or organizing towards other collective goals. And that's really what we want to hear from him about today, the sort of emergence and process that's going on right now surrounding gig apps like Uber, Foodora, all these ones that have been in the news recently. So Ryan, I will turn it over to you.
Perfect. Thank you so much, and thank you for inviting me to take part today. Before I put the slideshow up, just a bit more background in terms of the gig issue specifically. So I was counsel when the Canadian Union of Postal Workers, or CPW, successfully unionized Foodora, and I guess things move fast rather in the gig economy. So some of you may have forgotten Foodora already, as they left Canada about a year ago, but I had helped CPW win a certificate there, which was part of a longer campaign that I'll touch on throughout the presentation. And of course, that then meant as well that when Fedora did go bankrupt, shortly thereafter, I'd been involved in negotiating some coverage for workers who would have otherwise been excluded because of some of the very same factors we're going to talk a bit about today. And I did want to kind of hark back to Josh's presentation, which I thought was fantastic for a moment. At the very, very end, he had that unpaid internship ad that he put up on the screen. And I had not heard of Hello Work Inc. or .com. There's a few different iterations of it online. But I did search for it while Josh was closing up his conversation or his presentation. And what I thought was interesting was that not only are they posting what would appear to be illegal internship postings, but their slogan online, and I would love to share the screen with you, but it gives me some sort of security warning when I try to click on it. So I think you can make some conclusions about maybe the legitimacy of the company, but their slogan is the quote, the app that Uberizes hiring. So I think certainly one of the things you'll see when I take you through my presentation is that there's a great deal of overlap between a lot of the issues that Josh talked about and a lot of the issues I want to talk about. And I think at the core, there's really a few themes that kind of keep coming up. I think one of them is, an attempt to take vulnerable workers, young workers included within that, and kind of move them outside of, all of the protections that we've set up, even if those protections are inadequate, but all of the protections that have been set up to try and make sure that those workers have a basic level of employment standards. But also, I think it is in some ways a positive story because I think there has been a lot of fight back. Although certainly the positives there, I think, are a bit mixed in the sense that certainly industry is fighting back a great deal, and the government, I think, continues to have a lot of work to do. So without further ado, I'll start the presentation, and just like Josh, I'm going to take you through some slides. So I will share my screen in just one moment. So you should see that up on the screen now. And in terms of what I want to take people through with the gig economy, I want to do a few things. One thing you'll see in the presentation when I take you through it is, I think whereas Josh did a fantastic job of linking this specifically to some of the things you're going to see in your work or in your day-to-day as students, the gig economy is something I think you may be more on the cusp of. Most of the companies, this comes up in a later slide, but I've done some research in the lead up to this, and most companies will expressly state on their, either in their apps or on their websites, that you need to be 18 years or older to work through the app. So I expect it's the kind of thing where you may see students at the very tail end of their studies in high school getting a first job through Uber or Skip the Dishes or DoorDash or things like that. But you may not see it at all as well. Or you could see people, I guess, working through siblings apps and things like that. But I do think that there are some broader themes to talk about. And I do think, of course, it's certainly still one of those things that's very, very relevant to young workers, because if you're not working through a so-called platform employer or a gig employer, and I use those terms interchangeably in high school, you may by the end of it, and you'll certainly, I think, be doing it once you kind of go past your studies. So a few quick themes I think that are important to kind of talk about at the outset. One, I do think this functions the same as for the interns. The broader issue of misclassification of employment, I think, is really one of the best examples I think that you can come up with in terms of looking at the differences in the way that the laws are, say, written or articulated by tribunals like the labor boards, and how they're practiced in real life. And we'll put some more kind of meat onto these bones later on. But I think one of the central themes of this entire issue is the fact that companies who have been operating in the gig economy, just as companies that have been operating through interns, have always been very, very transparent about what they're doing, are kind of using well-known loopholes, and are really just daring people to stop them. And in fact, have generally not been stopped at all by government. And in fact, to the opposite, we've often seen legislation or regulations that have kind of aided this along, or at least enforcement of those regulations and legislation that has aided this end and this exploitation. I think one of the things that's impossible to talk about or not to talk about when talking about the gig economy is kind of the dangers of PR and brand attachment. These are all companies that have kind of branded themselves as tech companies. by and large. So I think Uber is the best known example, Lyft to a lesser degree. I think these are not companies that are operating at the margins of the economy. These are companies with billions and billions of dollars in investment capital, with very, very well-known high stakes investors, and the kinds of things, often when you do work through, with precarious workers or vulnerable workers, you'll see employers that are a bit more fly by night. And certainly that's not the case with the big platform employers. They are very, very large, and they've done a very, very good job of, I think, both endearing themselves to consumers, to young people, and also to governments. And we'll come back to that, but I think that's a myth that needs to be punctured. One of the things I wanted to, this is one of the few hopeful things I think in the presentation, and it was a kind of underpinned part of Josh's presentation as well. So there is some hope, is that we've seen very, very successful worker-led campaigns, both in terms of union recognition, in terms of class actions, but also just in terms of kind of basic organizing that affects day-to-day lived experiences. In terms of, in terms of kind of where that's going, though, it's not all good news, insofar as there certainly is, this ongoing struggle. And what we're seeing in part is now the big employers kind of push back and themselves make some gains. And I did want to close this talk by talking about a process that Josh and I have both been involved in, that's taking place right now in Ontario, and which will likely have a big impact upon gig workers here in this province. And so let's talk, and I try to make sure that everyone can see the slides advancing. I think I'm on Zoom daily, and it still fills me with so much anxiety. I see Josh giving me the thumbs up, so I appreciate that. So let's first talk a little bit about what gig work is, because I think one of the things that will be a takeaway from this talk is it's not really clear what we're talking about when we talk about gig work, and it's not something that I'm going to be able to resolve for you in the course of this talk. There are a few different kind of overlapping, I think, elements that we see in much of what we talk about when we talk about gig work, right? So we typically see that it's dispatch based. And so that includes kind of more traditional things like, Uber and Lyft. It includes things like DoorDash and Skip the Dishes and Fedora. It can also include a whole array of, different casual dispatch-based assignments in a variety of different sectors. And I'll take you through some of the different apps that have popped up. But to be clear, this is also very much kind of an old tech solution that employers have been employing and using to exploit workers for a long, long period of time. One of the things that you will see is kind of a constant factor is the downloading of costs onto employees, and that typically takes the form of forcing people to provide their own equipment. So of course, the best case examples are things like having to provide your own car or gas, or bike, smartphones, etc. And one of the key elements as well is that it's almost all on demand. So it's not just casual in the sense that you may not know what you're doing tomorrow, but it's all based on kind of being broken down into smaller tasks and being parceled out on kind of a task by task basis. And I'll come back to this when we talk a little bit about, I think, just the psychological impact of gig work as well. Certainly it's part of the legal landscape of gig work, but I think one of the things I want to make sure I don't simply just kind of gloss over is the fact that this is really, I think, changing the way that we talk about work. And I think it's kind of putting precarity, or making it so that precarity really is everywhere within the workplace now. And then the biggest thing, and I've bolded this, is that one of the biggest functions of gig work really, and this is not necessarily a defining feature, but it's something that we see time and time again, is that workers are often misclassified as contractors. And in fact, workers are invariably misclassified as contractors. And this is really where you see the hook for employers. So it's not just about downloading costs, but it's also about this kind of very active process of saying, look, we want to define your employment in a way that we can say that you're not employees. And I'll take you through what that means, why an employer wants to tell its workers that they're not employees, why it wants to say that they're contractors. But it has a really, really big impact in terms of an employer's ability not only to control people on a day-to-day basis, but to also do so in a way that they're doing so as cheaply as possible and undermining the social safety net as best as they can. And to be clear, while it's very, very cheap for workers, right, or at least very, very effective in terms of keeping down labor costs, one of the things we have seen is, the income of some of the CEOs of the big gig economy companies is enormous. DoorDash, for example, had gone public this year, and I believe the most recent estimate was that their CEO made $400 million in the calendar year of 2020. So certainly, it's keeping down certain kinds of labor costs, but inflating others. And one of the things that I think is really, really fundamental here is that this isn't new. And so certainly it may look a little bit new in the sense that smartphones have been around now for more than a decade, but certainly are more recent than employment itself, obviously, but it's not new. And in fact, one of the things that we looked at when dealing with the Fedora case was, basically looking at all the different cases that the Ontario Labour Relations Board had looked at. These kinds of arrangements go back into the 60s. When you first look at the kind of academic research that looked at the issues of people being misclassified, it goes back into the 1960s. But even trying to find some sort of middle ground. So, for example, looking for a dispatch-based employer who was utilizing an algorithm and a computer to assign people to shifts, we could see something that kind of fit that description as far back as 1992. So, decades and decades ago now. And so this isn't something that's new, and it's something that employers have kind of continued to push. And I think that they've made a renewed push kind of with the rebranding of the gig economy. One of the things that I think is interesting about gig work is that while it's very much work that's targeted at young workers, it's actually evenly spread out throughout the workforce. And I think this is actually an important thing to note at the outset, because I think one of the ways that the gig employers will try and I think kind of lessen the impact of what they're doing. You'll often hear this from people. They'll say, well, look, it's just people who are starting out, or it's young people who want flexibility, or they'll say, well, they're millennials or Generation Z, and who knows what they want in terms of the workplace. They want flexibility, or all this kind of stuff that really doesn't track when you talk to people individually. But I think it's important to kind of puncture this notion that this is work that can be substandard because they're largely a younger workforce. I think that's just fundamentally atrocious, right? It's not good reasoning. It's certainly not equitable reasoning, but it's also not true. It's spread out throughout the workforce. And one of the interesting things is it's actually of all of the populations that are overrepresented, those over 65 are the most overrepresented, which is not to say that they're the highest number of workers or the largest percentage of the workforce. But if you look at, say, the number of people who are over 65 in the population and look at the number of people who are working in the gig economy, that's where you get that disconnect. As I mentioned, all of the major apps have wage limits, or age limits rather. That's not to suggest that that can't be circumvented. It'd be very easy, for example, to have an older sibling who signs up, uses their driver's license or their ID to get work, or uses some other form of ID, which maybe is less legitimate, and then goes onto the app because there's not much oversight of who's actually doing the work. But there is a formal age limit on pretty much every single app. And it's quickly expanding into other work. And to be clear, in many ways, it's already there, right? Through temp agencies, and for example, particularly in the home care sector or in staffing of long-term care homes, something we saw a great deal during the early days of the pandemic. This model of kind of a central paced dispatch, signing up and doing it online. It's not just the Ubers and the Lyfts and so on that are doing this. But you are seeing kind of a more formal, or more traditional is the wrong word, but a more formal kind of expansion of the gig economy. And I've given you some of the different companies there, different apps. I think we all know what Instacart, Amazon's Mechanical Turk is certainly well known and is interesting in large part because it's kind of pushing the envelope in terms of what we think of as gig work, deals more with often tasks that are difficult to computerize, but can be done at home, so things like data review. And of course, general labor and healthcare is listed there as well. And I've just got some numbers here. I'll go through this quickly because I know we want to get to questions. But we know very, very little about the gig economy in terms of what its workforce looks like. Most of this relates back to a study that's linked in the bottom of the slide there from StatsCan in 2019, but it's certainly growing, and it now makes up nearly 10% of the workforce. And it's largely low paid. And so you'll see that the average net income in 2016 was just over $4,000. And that low wage workers are much more likely to be in platform-based work. And then just a few other things to kind of talk about in terms of both myths and also kind of recurring factors. So one of the ways that I think people often talk about gig work in a way that's meant to kind of devalue it or to kind of call it, to kind of undermine the questioning of its legitimacy is to say, well, look, this is all just short term. It's just people who've got a side hustle. And that's not really backed up by the stats. There's certainly a lot of short-term turnover, but more than a quarter have been there for 3 years or longer. And if you think about, what your job begins to mean to you after 3 years, you can see that for some people, they're very much a part of this economy in the long term. And just as with internship work, definitely kind of operates through the lens of vulnerability. And so we see more vulnerable workers being pushed into gig work. We don't have much stats. You'll see the last bullet point there is around non-status workers. There's not much information on that as you'd expect, but certainly when I was doing the Fedora work, one of the kind of recurring themes was that there was a large group of non-status workers who were working within the gig economy because one of the ways that they could get work with less oversight, less formal oversight of things like documents. So that's one of the issues. We also see that migrants are more heavily represented. Female workers are actually represented at a greater rate than men, largely because of the way that the gig economy has kind of expanded into caregiving fields. And so that's really what kind of a snapshot of what the workforce looks like. And then it gets to this issue of the effects of misclassification. And I anticipated that Josh would cover off some of this, and he did a very good job of it. So I want to kind of take you through kind of a higher level summary of it. But really, this is the fundamental issue, I think, both of the problem with internships, but also more specific to my presentation, the gig economy. It's really about an attempt by employers to try and take workers and move them out of this classification of people, employees, that we've given a certain type of meaning under the statutes, and to disentitle them to all the things that come with this. And I didn't put it into a slide because it doesn't really, it's almost too bewildering to even make sense of it. But one of the things that can, I think really drive the point home of the importance of classification is this, that largely in Ontario and anywhere in Canada, employment is heavily regulated by statute. And it's really, really atomized into smaller parts of, kind of what it means to be an employee. So just in Ontario, for example, on a day-to-day basis, if you're an employee, you have rights that come up under the Ontario Human Rights Code, right? So rights to be free of discrimination, for example. You have a right to a safe workplace under the Occupational Health and Safety Act, right? But those are two different pieces of legislation. They use two different definitions of worker, right? You have minimum standards that are guaranteed to you as part of the Employment Standards Act, which is a lot of what Josh had taken you through, the ESA, right? And then if you want to form a union, you have to look at a different piece of legislation, and that's the Labor Relations Act. And that's really where the big fight in Fedora took place. If you leave your work, say because of a pandemic, and you want to apply for EI, well, now you're dealing with the Employment Insurance Act. And if your company goes bankrupt, is what happened in Fedora, you're now dealing with an entirely different set of legislation. And again, different definitions at every turn. And it really does, I think, create this situation in which as a worker, you're largely left on your own to try and piece this together. And it means potentially as a worker, you're having to constantly fight and reassert your entitlement to certain benefits. One of the things that came up in Fedora was, we won the right to be certified. And workers would say, well, that's great. Well, now I'm an employee. I want to get things like minimum wage. I want to get things like vacation pay. And, it's kind of crushing then to have to go through this process of saying, well, actually, no, to do that, we have to file another, either a class action lawsuit, or we have to try and fight through the courts and the bankruptcy process, or we have to file another complaint with the Ministry of Labor, right? So it is really one of those things that's really, really difficult to wrap your head around, but certainly becomes fundamental. And here's just some of the more some additional details. This was something that became very, very apparent in COVID. And there has started to be some research on this, that most gig workers didn't feel like they were adequately protected during the early days of COVID. And this continues on today, right? There are some fantastic articles in the Toronto Star, for example, about some of the things that gig workers were doing, deliveries they were making of medicine and things like that, that made them feel uncomfortable, but also they were so precarious because they were literally going from kind of, delivery to delivery in order to survive, that they didn't feel like they could necessarily turn that down. And of course, the Ministry of Labor has not been particularly proactive investigating gig workplaces. We talked a little bit about the Employment Standards Act and minimum standards. The best research out there would suggest that compensation taken as a whole is 20 to 30% less for gig workers than it is for others. And that's more based around just the kind of employee versus independent contractor divide as a whole. I flagged for you earlier the problems with EI, the Wage Earner Protection Fund, which is the federal fund that permits people to recover some of their wages, say when there's a bankruptcy. And that was one of the things we had to fight with Fedora. And there's a broader issue as well. This just came out recently. It's not just about undermining, say, the social safety net for individual employees, but it's also a broader question There was a study that was released about a month ago that suggested that Uber and Lyft had been able to circumvent roughly $130 million in taxes. And that's just Uber and Lyft as a result of the ways that they had misclassified drivers here in Canada. And one of the things that I'd alluded to at the outset but wanted to come back to is I think when we talk about these things from a strictly legal perspective, I think we get focused on those things that we can easily quantify, like wages and so on. One of the things that came up time and time again when I was talking to workers with Fedora, one of the impacts of, say, the Labor Relations Board decision saying that in fact they were employees for the purpose of the Labor Relations Act was really kind of intangible, right? One of the things that workers would say is they say, look, I feel like an employee, right? I go to work every day. There's this other party that has all of this control over me, gets to tell me what to do. I don't set the prices with customers. I don't go out and recruit new business. I'm really just a cog in a larger machine. But I'm being told that I'm an independent business person, or I'm being told that I'm an independent contractor. And it just really does this number on, how they both interpret the world, but also how they interpret themselves and how they see themselves. This is the positive part, and I'm running a bit behind, so hopefully I won't have to gloss over this too much. But like I said, one of the things that has happened is that there was a successful unionization attempt. That was the Fedora case. Unfortunately, it didn't result in bargaining rights resulted in bargaining rights, but not in practice because Fedora closed up shop and left the country. There's an ongoing certification attempt with a subset of Uber. That's the Uber Black application that's ongoing right now. A number of class actions, both that our firm is doing, also that Josh's firm is doing, and others, where workers are really banding together and attempting to do what the government should be doing to kind of self-enforce their own minimum standards. And that's hopefully going to change things a little bit. And you also have groups like Gig Workers United, and these are all links that you can click on once this is distributed. If it's distributed electronically, and you can go look at those groups. And it's not just a local fight, it's very much a global fight, and we've seen major victories elsewhere. Often victories have been rolled back, but we've seen wins in Great Britain, in Australia, Italy, initially in California. That's been undone a bit. We've now got, and this is a bit of an oversimplification because Prop 22 is really just a piece of legislation that applies in California, but we are seeing platform employers fight back. They're heavily lobbying governments. They're looking to kind of protect this way of doing business, where they're able to kind of carve out their workers from all of the statutory protections. In California, they spent over $200 million essentially buying legislation that would exempt them from ongoing attempts, at the time, ongoing attempts to get them to pay up for missed minimum standards. And it's happening here in Ontario as well. Josh and I both made submissions to a provincial committee that is currently looking at gig work, amongst other things, in Ontario, and I expect we'll have a report due out shortly, which is being largely driven by Uber's desire to kind of create this new group of workers that they call kind of contractors-plus. And I think this is really where I think there's I think an interesting kind of point to talk to students, because again, this isn't just something that's being settled. It's something that's very much being contested on an ongoing basis. And I think something that students will, if they're not already in it, if they're 18 years old and working in the gig economy, certainly will find themselves in it shortly. So I want to kind of give you some closing thoughts there. And one of the things I want to talk a little bit, and you'll see that I've given a screenshot of a tweet from Jennifer Rose. Jennifer is the president of Gig Workers United. And I will admit that I love doing these talks. I always feel like there's, lawyers are never a substitute for workers. And I would certainly say that of all of the things that you can do to get involved in this, or to help out gig workers, or to understand the gig work issue, I think certainly listening to gig workers is kind of the primary issue. And I think this is one of those things that's interesting to me, at least, in the sense that when I was asking Jennifer about what are the kinds of things that she would say if she was presenting to this group, certainly one of the things she wanted to talk about was what I've covered off, right? The fact that people are trying to find unions, they're trying to band together and oppose their employers and push back on attempts to exclude them from statutory minimums. she would have also wanted to talk about the fact that there's all these other, parts of working that aren't covered by the legislation, but certainly are tied up in what companies like Uber and Lyft are doing, right? One of the big fights that has come up just recently is that Uber, for example, around Uber Eats, just changed the time that you've got to make a decision on an order. So you've actually got an incredibly small amount of time to make a decision. I think it's as little as 15 seconds. One of the things that workers have talked about is there's really no way, for example, if you're biking through downtown Toronto or in some other smaller city, to actually hear your phone ding, stop, make sure you're being safe, get out your phone, look at it, make any sort of informed decision about the next thing you're going to do. That in fact is just pushing you into this world where, one, you can't stop because everything is kind of task driven, but two, where, being able to balance all of the things like working safely while at the same time with, making sure you're able to get additional work becomes increasingly hard. And it has this toll that it takes on workers. And certainly one of the biggest things I think that certainly I would say to young workers and people like Jennifer would say to young workers is, just the need to fight back, not just in a legal sphere, but also in terms of, making sure that you're organizing so you get the benefits of, that kind of common fight. So you're pushing back and making sure that you're looking after your mental health when you're kind of working in that go precarious fashion, but also that you're kind of questioning what it is you want in a workplace and what we all collectively want in a workplace. And I think also if people were looking for resources, I would certainly encourage you to go and follow someone like Jennifer on Twitter, to go and talk to some of the people in Gig Workers United. But definitely Sarah Mostazahade at the Toronto Star did a fantastic podcast that came out last year, just at the very beginning of the pandemic. So it definitely covers some of the pandemic. It was called Hustled. You can find that online. It was really a fantastic deep dive into the gig economy in a way that I think I really can't do in this context. So I'm going to stop there just because I know that we're kind of giving you a lot of information in a very short period of time. And also I think we're really at the end of the presentation as it was. But I want to make sure that people have some chance for questions if there's time.
Thank you so much, Ryan. This whole subject is so interesting. We did drop links to both Jennifer Rose's Twitter and the podcast that she recommended called Hustled in the chats. And I think we've had some other people kicking in references to really useful places like I think Ryerson's student young workers rights hub, which seems like it would be an incredibly useful thing. It is a few minutes after 3, so for anyone who needs to run, thank you so much for being with us. I'm going to take 1 second here to, I hope we'll have a second to take a couple questions, but just before you run, I just wanted to draw everybody's attention to the rest of the great program that we have coming up over the next 2 weeks, to point out a couple of sessions. Tomorrow, we're doing one that is essentially an overview of everything that OJEN offers high school teachers. So all of the services, how to do things like book a speaker for your classroom, to have someone but not exactly Josh come and talk about internships, or to find out more about gig apps, anything. We will be having a number of really education law focused sessions, including one called 3 Areas of Law Impacting Your Student Outcomes, that talks about the legal framework around special education and about refugee youth who have been in the child welfare system and are aging out of it. Lots of interesting stuff. A session on paralegals and careers in law that are not just lawyers, the Black Legal Action Center on anti-Black racism in schools, and of course, we'll be ending with our annual tradition, doing the top 5 most significant cases of the past year, this year hosted by Sonia Lawrence, an outstanding legal academic out of Osgoode. And we wanted to invite you all to join us for the Hux Kitely Exemplary Justice Educator Award ceremony on August 26th at 5 p.m. We'll be honoring Kim, who you can see on the right here. And there's an email address on the screen if you'd like to RSVP for that. Otherwise, all the registration information is on our website. And I want to say thank you to the Law Foundation of Ontario, which makes it possible for us to present all of this programming free of charge, along with all of the generous individuals who share our vision of access to justice and broadly available, reliable youth information. But if anyone else has questions, please feel free to drop it in the chat. I think, if I was going to toss one thing at you guys before maybe in the next 2 minutes before we sign off, it occurs to me that both of these are also fundamental rule of law issues, right? I mean, it's hard to overstate how much, gig apps like Uber and Lyft entered this space very aware of regulations around, employment issues and independent contractors and frankly, taxi certifications and all of that stuff. And really, you said it was daring people to come after them. It occurs to me that both of these things plug into much larger issues in the justice system and the uneven application of legal regulation. But if we only have a couple minutes left, I wonder if either or both of you could tell us a little bit more about the push for the contractor-plus classification, because I know that's ongoing, and so you can't give us conclusive information. But what is that? What are they asking for? Do you have a take on that?
Sure, maybe I can jump in quickly. I know Josh wrote some fantastic submissions for the OFL, and he can speak to that as well. I mean, largely what they're looking at doing, and it comes a lot from Uber, like that specific term contract plus actually comes from a press release they sent out in May. I think what they've recognized is that the tide is turning, right? Every single jurisdiction uses a slightly different test. I didn't take you through the test here in part because there's about 4 or 5 different tests depending on what piece of legislation you're talking about. But the outcome of those tests when they're applied, which kind of broadly look at things like control and integration, have found that gig economy employees are just that, they're employees. And Uber in its IPO documents a few years back had kind of flagged misclassification as this enormous issue in its business model, and that if suddenly that, if the tide kind of turned legally, if suddenly they in fact were found to be misclassifying workers in order to pay damages, and there was just a class action that was certified last week, and that's now going ahead to kind of the stage of having to prove those damages. But if those ever actually came to fruition, that they'd be cooked. Their model would fall apart. They'd owe a lot of money, and they would presumably be going bankrupt. And so I think Uber's very, very intelligent company. All of these companies are very, very intelligent. They're not, they're doing it, I think, because it's the fact that it's immoral is not the reason they're doing it. That's the thing that doesn't stop them from doing it, though. And so I think they're now looking at, well, what is some way of kind of blunting that change? And I think one of the things they're trying to say is, well, couldn't you be contractor plus, right? Couldn't you be, say, they've kind of tied being an employee as being inconsistent with kind of flexible terms of employment. I mean, that's not true. It's a bit of a myth. But they've said, look, to workers, if you want to be flexible, everyone loves flexibility, then, you should support us. And what we're going to propose is some sort of middle ground. So, probably is going to look, no one knows what exactly it look like. It probably means some sort of carve out in the States where it came up first. And as part of Prop 22, it's meant carve outs from things like minimum wages and so on. But so that's likely what they're looking at. And I think we're all just waiting to see what the Ford government dreams up in the next month or so.
Yeah, Ryan hit the nail on the head there. Just a couple points to quickly add. They are looking for a carve out. That's what Uber and the gig companies want. They're pitching it as an enhancement of rights because it's, theoretically slightly better than the current independent contractor model, but it's a bit of a bait and switch. It's really about carving these people out of employment status forever in exchange for a sprinkling of additional benefits. The position of the OFL and the labor movement and workers groups and gig workers themselves has been pretty consistent and united. The only fair future for gig workers is employment status and equal treatment. I'll link in the chat the OFL.
Josh, I think you accidentally muted yourself there.
Shoot, I was just saying I tried to click enter and I muted myself. I was just saying I just sent a link in for the OFL submissions, which deal with some of these issues, and towards the end of it set out what we think or what the OFL thinks would be sort of a progressive path forward for gig workers.
And that's, of course, the Ontario Federation of Labor.
Of Labor, yes. Sorry,
Right.
I should
Oh, that's okay.
explain terminology before I'm using all these acronyms.
That's all right. Well, I mean, I don't want to keep you guys too much longer than this, but I do want to say we've had a bunch of people popping up in chat to say thank you. This was really informative and will be helpful with students. So Riot and Josh, thank you both. I'm sure it's a busy time in both of your offices as well. And it's just been wonderful to sit down and learn a little bit more about these very topical items. So everyone who is still here, I think Christy is going to drop a link in chat to the sort of feedback short survey that we would love if you would fill out. Don't worry, we'll email you a copy if you don't click on it now. But otherwise, I hope we'll see some of you again tomorrow or at other events of the Summer Law Institute. And we wish you otherwise a very safe and smooth return to another challenging year. All right, thank you guys.
Thank you.
Thank you so much for having us. Bye-bye.